Good morning, everyone, dear colleagues, speakers. My name is Jenna Barros, and today I have the honor of being a master of ceremonies of these panels. I would like to thank IWIRC Brazil and our president, Liv Machado, and especially to thank all of you for being with us today at our event. We start today the third International Congress of IWIRC Brazil, which is the national network which is spread out through many continents and 20 plus countries, enhancing the members and networking. We are proud to have an event mostly by members of our institute, high qualified professionals who stand out in the field of insolvency. And remembering you that you can join us on YouTube and our social media, and that we will be broadcasting this originally in channel 1 and translation into channel 2. Finally, I would like to thank the sponsors who have made this event possible. In the platinum category, we have Vicelace Advogados, Telsberg Advogados, Galdino Coelho Advogados, Lefonso Advogados, Machado Meira Advogados, PJ Law Advogados, Pinheiro Neto Advogados, Sequan Law, Fosini Feire, and Veirano. In the gold category, we have Paoli Palbini Albarros, Duarte Forcel Advogados. In the silver, AJ1 Administração Judicial, Bielke Empresarial, Bemachara, Saneca Advogados, Moraes Júnior, Tauer Sheker, Salusti Marangoni Parente de Agura, Ex-Led Administração, Titanium Catapult, and Zapaz Administração Judicial. I would also like to thank our institutional supporters, CMR, the Center of Women in Corporate Reorganization, FONAGEM, the National Forum of Judges of Corporate Law, IBAJUD, the Brazilian Institute of Insolvency, IBD, the Brazilian Institute of Corporate Law, and IRB, Instituto Recupera Brasil, JPL, the International Association of Portuguese Language Young Lawyers, and Insol International, who's our institutional support and international support. So let's go now into the opening session, which is called Be Yourself a Part, which will count on our president of IWIRC Brazil, Liv Machado, who's a partner at Tosini Freire and Insol Fellow, and Dr. Leisa Blanco, who's a chair of IWIRC International and partner at Sequan Law. So without further ado, I'd like to call our first panel and to give the floor to Dr. Leisa Blanco, our international chair. So Leisa, please, and good event to all.
Bom dia. É uma honra estar aqui com vocês, meus colegas brasileiros. I'm Leisa Blanco. I'm the shareholder at Sequan Law in Miami, and I also serve this year as IWIRC's international chair. For more than 25 years, IWIRC has been an organization committed to the connection, promotion, and success of women in the insolvency and restructuring profession worldwide. IWIRC was founded in December of 1993 by 3 women, Celinda Melnick, an attorney, Lauren Ryan, a financial analyst, and Martha Fettner, an investment banker. And they founded IWIRC to empower and encourage women in the insolvency field from all aspects and professions that touch our area. The first members of IWIRC joined in 1994, and with 3 first networks established in 1995, IWIRC has not stopped since. As IWIRC's first Hispanic chair, I set my sights on bringing IWIRC to Latin America. And as a result, IWIRC Brazil was the first IWIRC network born in Latin America. So it's a very, very near and dear network to me. I feel like I'm at home at IWIRC Brazil. IWIRC Brazil was the network that inspired the growth of IWIRC in Latin America. And most recently, IWIRC Latin America Network was also born. And I think we'll have very soon other Latin American networks soon to follow. So this year, we have seen both growth in the Latin American region as well as in Asia, increasing the diversity of IWIRC membership ranks. We added Korea, Malaysia, and soon Indonesia networks, as well as the strong presence that already exists in Asia. And we also saw this year the birth of IWIRC Ireland and the revitalization of IWIRC Europe. So we're definitely a growing group. And as an international organization, IWIRC offers its members an opportunity to be leaders involved in both global, regional, and local levels. The International Board of IWIRC creates programs to foster national and cross-border relationships and education, very much like this conference here today. And global conferences are scheduled in conjunction with other major restructuring conferences, so we leverage our business development opportunities and our travel budgets. So I encourage you to take the opportunity, and when we resume to whatever our new normal will be, whether virtual, hybrid, or in person, I encourage you to attend these international events of IWIRC International so that you can meet such great women around the world that are members of IWIRC. The local networks like IWIRC Brazil organize professional, educational, and social activities within their communities and their regions, which are structured to meet the specific needs and interests of their members. And these conferences like this one are ideal for meeting other professionals in a welcoming environment. Even for young professionals who are eager to learn and polish their networking skills and developing their leadership skills, IWIRC international and regional conferences are ideal. So both local and international offerings offer a potential for leadership opportunities for those seeking to take their careers to the next level. IWIRC networks are also located in, as I said, in Asia, in Europe, in the Caribbean, in South America, and North America. And we welcome the development of any new networks in these or in any other regions. One of the things I love most about IWIRC is that it honors women for their recent contributions. One of the greatest, proudest moments I've had as chair of IWIRC has been to present these wonderful awards this year to women that are so deserving. This year, I presented the IWIRC Woman of the Year Award, which I love the name, Woman of the Year, who honors a woman for her recent contributions and her lifetime achievements as part of the insolvency and restructuring industry. This year, Deb Grassgreen was our winner, and she is just a fantastic, fantastic deserving recipient. I'm getting ready to present the Rising Star Awards, which are coming up in the fall. In furtherance of IWIRC's mission, we are devoting to enhancing the professional status of women in the insolvency and restructuring profession. IWIRC established an award some time ago for individuals who are rising stars of IWIRC. And they are women who are in earlier careers, early in their careers, and they want to, and they are leaders in their fields. So IWIRC wants to recognize and honor these rising stars of the organization for their contributions. I encourage you to join us either in person or hybrid by video, because I know it's so difficult with the present pandemic to travel, but it is one of those wonderful presentations that leaves everyone inspired. So join us in the fall for those presentations. As you can see, I'm very passionate about IWIRC. I brought IWIRC to my Brazil friends because I love it so much. I joined it very early in my career and decided that it was the organization that I one day wish to lead, because women who support each other, and when they support each other, incredible things happen. And I have seen that along the way in my experience with IWIRC. Paying it forward, just taking a little bit of what people have done for you and passing it along to women, the younger women who need our support and our guidance. And so, men in the audience, I haven't ignored you. Your support and sponsorship is key to the success of IWIRC. So if you're here, thank you. Thank you for being here. Thank you for your support, and enjoy what I'm certain will be a fantastic professional and educational experience brought to you by IWIRC Brazil. These women have put together a fantastic panel for today and each of the days that IWIRC Brazil is putting on this conference. So I encourage you to continue to participate and support IWIRC in all of its present and future engagements. As chair of IWIRC, helping to form IWIRC Brazil has been one of my greatest accomplishments, and I want to see this network continue to grow and succeed. Thank you, Liv, and the board of IWIRC Brazil. for inviting me to share these thoughts with you this morning. Enjoy the conference and make the best of your membership in IWIRC this year. Remember the power of women working together, and always think IWIRC first, because you can be informed, be inspired, and be connected, and choose to challenge as a member of IWIRC. Thank you again, and have a great day.
Muito obrigada, Leisa.
Thank you very much, Leisa. That was incredible to hear the history of IWIRC, and especially your passion, your incredible passion, the one which I share today. And for that reason, that's why I joined IWIRC. And since last year, I took on this big challenge since October of last year of becoming the chair of the Brazil network. And after Beatriz Vaneca, who continues to be very active together with our board. And here I'd also like to welcome everyone and to thank all of you to be with us on behalf of our board. So I'd also like to introduce our board. For those of you who don't know, Dr. Anglise Oliveira is our academic board member. We also have Dr. Juliana Sato, who's our financial manager, Dr. Tatiana Flores, who is our communication director, and Dr. Rebecca Oliveira, who is our projects director. And obviously, I can't forget to mention our vice chair, who's Flavia Milad, who has helped us a lot in all of our activities. So on behalf of all of our board, I'd like to thank all of you for being here today. And I'd like to tell you a little bit about IWIRC here in Brazil. As Leisa has mentioned, this was the first IWIRC here in Latin America. It exists since 2018, so it's still recent. We are still building growth movements and union of women here in this region with lots of success, I could say. I believe that today we have the result of our panelists. The majority of our panelists are members of IWIRC Brazil, and we also have the honor of having the panelists of IWIRC of other networks. So as Leisa has mentioned, we have IWIRC in Asia. We have the pleasure of hearing Ming, for example, from IWIRC in China. And we also have a member, Sheila, who's a member of a Singapore network. And we also have the honor of receiving 2 members from IWIRC Latin America. We have Dr. Susana, who's a judge in Colombia, and Dr. Maria Orska Vertis, who's from Mexico. And these panels reflect the plurality of IWIRC, of our networks in contact, in a constant contact. And this is our idea. I believe our unity in Brazil to have this international networking and at the same time to learn a lot and to exchange our experiences, not only amongst ourselves, our members in Brazil, but with our sisters who are from other IWIRC networks in the world. Apart from all of these, we're going to have a panel with Leisa's presence, so you've had the honor of hearing now, but she will also be a member of one of our panels. And apart from being a chair, she has all of this incredible experience from IWIRC to share with us. Nayana Miller, who is also a crucial member in creating IWIRC Brazil. And she's also director of IWIRC Latin America and also present at our events and in our initiatives in these panels. We will have a pleasure of hearing her. And I believe that's the idea, to share a little bit of the spirit of IWIRC, this spirit of congregation, of union, and of international experiences. I'd also like to give you some examples so that everyone can have an idea of how this works in practice. Unfortunately, in this year of a pandemic, it wasn't possible for us to have our in-person meetings, but we've tried to rescue this with the video, right? To having our video sessions, and we've had some happy hours. We had a happy hour with between Brazil and Latin America. We've had a virtual happy hour also with China. We had a virtual happy hour with Singapore. And we have also had a workshop, which was incredible, on international presentations. We've had 2 sessions of this workshop, and our US colleagues introduced them for the Brazil network in Latin America. So these are experiences which bring us this idea of the knowledge and the technique, as well as the issue of the networking, of getting to know women in other jurisdictions, in other countries, and not only to expand knowledge, but also our network, our contact network, right? The networking. I think this is very cool, very interesting. And this is one of the main lessons here of what we have at IWIRC. And now going a little bit on to our Congress, our panels have a diversification of topics. Many of these topics, we've obviously seen a recent reform in the bankruptcy law, and lots of these topics are connected to these main topics of the reform. Today, we have an opening panel, which is very much connected to the Institute, this issue of cross-border, of international, and this represents a change that we have had in the national law. And I think this will represent our spirit of our institute. And for this, we've prepared a surprise. And this is for some of the people who are watching us. And I'd like to share with you the kit which we have prepared here, which is special. This is a glass with our logo and a gin, a tonic. Look, because it's great to learn a lot, etc., to expand our technical knowledge, but it's also very cool for us to be able to celebrate, sit back and relax. So all of our speakers will receive this kit, and this kit will be drawn during the 3 days of events. We are starting today, and Tuesday we will have another session on Thursday, and next week on Tuesday and Thursday. So every day we will be giving out one of these kits for those who are watching us. And at the end, now I also need to bring you the next surprise. CMR, who are our sisters here, the other very cool institute of women here in Brazil, has kindly given us 4 copies of this book, which has been recently published, which also has articles published by women, many members of IWIRC, even Juliana and Mariana Otomani, and who are members, and they are the organizers. And we will also be drawing this book 1 per day, 1 copy of this book. And on the last day, we will have a combo of a book and our kit, and we will give this to the person who interacts the most during the panels. So those who participate more actively, send questions to our speakers, that person who interacts the most will be getting this super kit, which will be the CMR book, as well as our exclusive gin glass with a small gin tonic. So this is the surprise which I wanted to share with you. And once again, I'd like to welcome all of you. This event will be a very interesting event. I ask all of you to please interact very much with comments, questions. I think that's the idea, to create a bond, which is still virtual. I hope at the next version of our International Congress, we can do it in person and that we can see each other and interact. But so far, this is what we have. I hope this is the last virtual version. Who knows, the next can be hybrid or preferably in person. So greetings to all. we see you all in the next few panels, and I thank all of you and all of you who are watching us, all the speakers who've accepted the invites. I know Gianna has mentioned this, but I'd also like to give a huge thank you to all the sponsors. Without them, this event wouldn't be possible. And to our institutional partners also who have greatly supported us in organizing this event. So I wish you all a great day. Thank you. Thank you, Liv. Thank you, Leza. It's really very inspiring to hear the history of IWIRC, how you do everything to make it grow and grow more and more every day. It's really a great pleasure and happiness to be part of a group like this. So now let's switch the panel. So I'd just like you all to wait for a few seconds while we switch to our first panel. Thank you very much.
Muito obrigada.
Prontinho, pessoal. Áudio fechado.
Show de bola. Então, Liv e Leisa, se quiserem acompanhar, tá?
Bom, pessoal, obrigada por terem estado
Good
conosco.
morning, everyone. Thank you for being with us. We're back again to start our first panel after the opening panel. I'd like to welcome all speakers. Our next panel is called Transnational Insolvency, Communication Between Judges in Practice. Once again, I'd like to welcome our speakers who have given their time to be with us today and sharing also their knowledge. So we will count with the participation of Honorary Aline Mendes de Godoy, a judge of the Third Court of Aranguá, Santa Catarina, member of IWIRC Brazil, Honorable Anglise Oliveira, a regional specialized judge in reorganization and bankruptcy in Cuiabá, Mato Grosso, and the academic board member of IWIRC Brazil, Honorable Eric Kimball, a bankruptcy judge in the United States in the South District of Florida, Honorable Monica de Piero, an appellate judge of the state of Rio de Janeiro and a member of IWIRC Brazil, Honorable Susana Arango, a superintendent judge of insolvency procedures in Colombia and a director of IWIRC Latin America, and Honorable Maria Cristina Zucchi, appellate judge of the state of São Paulo. So I'd now like to give the floor to Aline, who's our moderator for this session, and I'd like to thank all of you and especially our speakers. Thank you very much. Good morning, everyone. I'd initially like to thank IWIRC for this invitation on behalf of our chair, Dr. Liv Machado, and to say it's an honor to be with you in talking about international insolvency in the Brazilian law, which brings such a new and challenging topic, which has brought us many questions. Today, we will have fantastic speakers who will be part of this event with us. These are specialists on this topic and will be telling us a little bit of their experience, bringing us profound reflections. So let us start this panel. I'd like to give the floor to Dr. Anglise, who will be telling us a little bit about the adaptations and incorporating throughout Brazil the directions for the cooperation in courts in terms of transnational insolvency. Good morning, Anglise. Good morning, everyone. I'd initially like to greet Maria Cristina, Monica, our mediator, Aline, Judge Kimball, and Susana. For me, it's a great honor to be here in such a carefully prepared event. I am the academic board member, and I would like to greet all the other people involved in this event on the name of Dr. Aline Machado Beatriz Faneca. Why? Because this event involves a lot of dedication, a lot of apprehension, and we have the majority of women as panelists in an area that we don't have many women talking about this topic, which is the topic of insolvency as a whole. And for me, it is a personal achievement and also as a judge. So these are other people without not giving prestige to the man. This is something which is accepted in commercial law. And I really feel this is a great achievement at this time beside my dear colleagues in Brazil and in Colombia and Judge Kimball. I'm going to be giving you a very general overview of what has happened in Brazil in the last few years with the adoption of this model law. In Brazilian law, it didn't have a positive rule on transnational insolvency. And this made lawyers seek other sources, and this was a reason for instability. As Dr. Aline has mentioned, the recent reform of the law, Brazil has incorporated the ancestral model law including Chapter 6A in this law 11-101. Despite some delay, as this reform is something which has happened now in 2021. So this adoption of a model law for us is a very relevant advance because Brazil is a significant economy in the global scenario, and we have large multinational companies established in Brazilian territory. Brazil, possibly due to the lack of rules, we register very few cases, a low number of cases of knowledge sharing, and also an unfavorable history, which can be explained because of the lack of rules. This discipline of the law, which I mentioned, is something which is fully in line with this cooperation with judges and other competencies in Brazil and in other countries, and it privileges the same lines found in this model law, which are to increase the legal safety, efficiency, and the celerity, especially in my opinion, for the protection of the rights of creditors, debtors, maximizing the values of these assets which are protected, and facilitating the recovery of the company. So when we look at the legal rules, we will realize that the procedure is extremely simplified, and the person should present a request with the existence of a foreign proceeding and that they are the respective legal representatives. And this is something which, depending on the situation of a country of origin, of a country where this case is coming from, and the judge will verify if there's a copy of a decision. And this is something that if that person is truly the representative, and therefore to make and be sure if there's an interest to see this recognition in Brazil. This decision of the judges who receive and allow this request is recurrent, and the decision of a judge are similar to when you start a local proceeding for reorganization or bankruptcy. The judge can grant an injunction to protect the interests or of the trustee, and the law, it emphasizes to the Brazilian judge to have extensive powers to grant any measures which they believe are appropriate, be it in the main proceeding or in the local proceeding. This allows you to produce evidence, have a discovery phase, and also for you to conduct the different proceedings. The judge who will receive this request in Brazil is the state court, and it's the state court which would be competent to recognize this foreign proceeding. Oh, sorry, what I mean is that it's the judge that has jurisdiction in the main location, the main office of the debtor in Brazil. This is the judge who's responsible for receiving the foreign proceedings. Something which stands out, in my opinion, in this sense is the informality of a communication between judges. The participation of this part of communication, this is when we see more legitimacy, and this is exactly this communication which that has the decision of CNJ Resolution 394 of May It's a very recent resolution which establishes recovery and communication rules directly with the Brazilian judges and the foreign judges. This resolution establishes that this relationship which exists between the judges will have as a basis what has been established in the insolvency protocol signed by both judges. This protocol will discipline the communication which will take place between the judges and also how these activities are coordinated. In the resolution, there's a recommendation that judges follow and observe best practices established by the Judicial Insolvency Network. So this communication is a direct communication, a court-to-court communication. It's important to emphasize that in these insolvency proceedings, the judges will say that this is restricted to the procedural aspects. Obviously, the judges won't be able to make any type of agreement on aspects of material law. This agreement, this protocol is on how the communication and those measures, for example, how they will communicate by email, by telephone, how these joint sessions will be taking place. It is truly the way of the form of communication. This first protocol, the one which will define the rules, it can be done directly between both judges without the participation of third parties. And all others would be in line with our rule, the local rule, the Brazilian rule, and we would have a participation of all the parties, except in exceptional situations which are previously established. And these parties would be summoned to participate in acts just as in other Brazilian procedures. This incorporation of the model law was a very important step in the Brazilian law. It's a big challenge, the issue of cross-border insolvency, because the company is in a cross-border situation because they're present in other countries, but the legislation in the location where they operate has to be respected. Therefore, I think this is very challenging, especially because the judiciary is based on values of hierarchy, etc. And this direct communication, issuing the rogatory letters, the sworn translations, and this communication, this is something which at the beginning can cause a certain surprise, but I think this is a very efficient manner. This is something which brings a lot of speed to insolvency. I think it's interesting because there's an informality, and this is a communication of the proceedings. This is regarding the means, but not on how it is done. In other words, they continue to be public. The parties participate. So this is something which is a way, in a very simplified manner for us to say this. This is the way for one judge to speak to another. The adoption of the model law, this revolution, the disciplines which we will be looking at and communicating, this shows more safety for the parties, for the judges, and brings more speed and this bureaucracy, and looks at the unpredictability of this topic. And we need time to be able to observe how this will behave, how the judiciary will behave regarding this topic. I wait for my colleagues who will be giving us concrete cases on the solutions which have been brought by these concrete cases. I'd like to thank you for the opportunity and wish you a great day of events. We will have 4 days of event, so I hope this is very fruitful for all, and this is a way for us to talk on more specific topics on the global nature of this institute. And I think this is something which is very rewarding and makes me very happy, and I thank you profoundly for this opportunity. Thank you very much, Dr. Anglizé, for this presentation. These are truly new challenges which have been set forth, and to be able to hear the other judges who have more experience will definitely bring us great ideas. So I'd now like to give the floor to Dr. Monica De Piero, an appellate judge, an IWIRC member, who today has published an article together with Justice Luis Felipe Salomão on the judiciary and the regrowth of the economy in Rio. Dr. Monica, the floor is yours. Good morning, Dr. Aline, you're impossible. You're impossible. How did I guess you were going to ask me to talk about this article which was published today? It's always a great pleasure. It's always brings me much joy to be here in our IWIRC. Allow me to say our. In IWIRC, I have this great feeling that it's a little bit of each and every one of us. And Judge Kimball, it's nice to have you here, Judge Kimball. And I think the last in-person event in IWIRC, and I say this again, was here in Rio de Janeiro, if I'm not mistaken. Liv must be hearing us. I think the last time we were able to hug each other was at the event organized by Bia Faneca. And I hope that shortly I may be able to come back to this personal meeting amongst us with all of you, which is so healthy, not only in our professional work, but in our personal work. So cheers to all of us with our virtual gin tonic glasses, I'd like to greet all the members of our panel, and in doing so, I'd like to greet my dear colleague, Dr. Anglizé. Congratulations, Dr. Anglizé. As always, you are very serene, very appropriate in what you say. I always like to publicly recognize how much I admire your position as an appellate judge. You are a judge even when teaching. And on Anglizé's name, and Aline, my dear friend and colleague, all other colleagues, Susanna, Dr. Cristina, Judge Kimball, I'd say hello to you, Liv, Bia, Gianna, Jenna, who's acting as our master of ceremonies. So I obviously can't forget Carol Merizio, who has also helped us a lot during these events and this dedication in our network.
Hi to my friend Liz. Liz, I saw you. You are so beautiful today. A kiss for you and a kiss to Nayana. Continuando nessas questões.
So continuing with these issues of the court to court and the cross-border aspects of our current law 11101, I'm going to try to share with you very quickly my personal experience as an appellate judge, as a second instance judge, of a reorganization proceeding which was approved in first instance in June 2016. So this was of an economic conglomerate with an impact of great social relevance and economic relevance for the economy of countries. This request was approved for a group of companies established by publicly traded companies in Brazil, as well as some companies that were not publicly traded. And also the legal entities of private law set up according to the Dutch law. The conglomerate, I'm going to use the term conglomerate, but in reality, it's an economic group. We have before us a group of companies. I'm calling it a conglomerate, which was a provider of telecommunications services in Brazil and in some countries in Europe, but was responsible for 330,000 kilometers of fiber optic cables. They operate landline telephony in South America in the segment of personal mobility, which is obviously cell phone technology, broadband internet, and all of this with a huge corporate commitment within the company itself. And multiple reasons led to an economic crisis, including the issue of global competition. At the time, this reorganization process, as I mentioned, which was in 2016, was for us a challenge. I think it was very bold in our proceeding. The use of a legal system in this procedure for reorganization was very bold, a challenge. This is a cross-border insolvency scenario due to a globalization of the commercial relations developed in many different continents. These were unforeseen issues, never seen before, never approached,
Da aceitação do pedido do processamento pelo juízo.
even when being handled by the judges of the first instances, in the recovery of the foreign aspects without a branch in Brazil. We were observing the universal aspect of the use of protocols, in some cases of the model law of UNCITRAL, as well as the European rules, which dated from 2015, which were very recent, 848, Rule 848. And in the preamble, it already establishes that their clauses should be included in the decisions related to the same debtors or to members of the same group of a society of a. We were the inspiration we had at that moment. Seeking new markets to be able to obtain investments, which was done in this concrete case, had a trend to open the jurisdiction, this broader trend to open national jurisdiction of countries at the scope of international competencies. Law 11,000 for the reorganization and bankruptcy, which is applicable at the time in its original wording, did not have any chapter on cross-border insolvency. Only in its third article did it talk about the competency of the local judge, establishing that this should be done in the site of the main establishment of the debtor or of the branch of the company which had headquarters outside of Brazil, in order to approve the plan. And on that site, the judge was also competent to process the recovery, the reorganization. This is the legal subsidy that we had. The law also determined our civil code, our adjective code, and did not have, as we didn't have any specific law, any rule on cross-border insolvency. Therefore, we only had rules on this, generic rules on the cooperation, the international cooperation. The doctrine and jurisprudence was seeking solutions between both models, both academic and technical models, and the universalism. The legislative gap, we used the law that introduces the civil code in its 4th article, which establishes that when the law was not was amiss, they had to use the principal rules of law. So this became something which was mainly used in our decisive aspects of our decisions, because in this way, we corporate judges here in January in Rio de Janeiro, in Brazil, we started this reorganization of an economic group of this following 1 or 2 precedents, and also inspiration in US law, which already applied the UNCITRAL principles. This was the very first time, and this is something that I can definitely tell you, that our professor and consultant of international private law, Nadia de Araújo, this is the first time that we were able to see that there was a transnational, which is a legal fact, which has binding with many different legal rules and not being something which is positive here in our country. The Dutch companies set up in the Netherlands, as a decision from the Amsterdam Appellate Court, also had their bankruptcy declared concomitantly with the bankruptcy here in Brazil. This decision was confirmed in the Netherlands by the Supreme Court, and there was also a decision during our proceedings here. And in that time, the Dutch societies therefore started Chapter 15. I think they went to the Southern Court in the Southeastern Court. No, the New York Southern District, sorry, the New York Southern District. They took to the Southern District Court in New York a request for the judge based on Chapter 15 to decide what was the main proceeding where this judicial reorganization would take place. I'm not going to delay myself. This is a very interesting proceeding. I have it here with me. It's a very lengthy process, but this is a teaching for each and every one of us. They bring a concept of a company in accordance to UNCITRAL. The description is perfect because it depicts, there's a very significant and detailed report with, they hear the parties, but what most impressed me in this case, and this is the decision of the judge, is that the analysis is always done on 2 principles: the good faith of the creditor and of transparency. Those are the 2 pillars used. This was concluded, and the US court decided the main proceeding and decided that our court, the Brazilian court, was competent, the 7th corporate court in the city of Rio de Janeiro. And with this, the local judge guaranteed the prerogative of a Brazilian conglomerate to have the controlling aspects, and they recognized the administrators of the Dutch company. They gave them the power to manage the case here in Rio de Janeiro. So without any proceeding, without any aspects which regulated the transnationality. This was the European inspiration and the US inspiration that brought us these parameters to decide, and apart from recognizing that the main proceeding was in Brazil, but they also recognized the nomination of the judges in Brazil to represent them both in Brazil as well as abroad, and the validity of all measures taken by the representatives, highlighting the respect to the jurisdictional control set forth by the US judge. Why am I giving you this information and supporting my talk back in 2016 in my experience? As you can see, we have had our jurisdiction, which is considered competent, and these Dutch companies, which were part of a company, were longa manos of the Brazilian companies. They didn't have any assets abroad, or they used to issue, to be very practical, they were issuers of bonds. They used to put the bonds and raise funds in the foreign markets with those securities to be able to financially support their operations in Brazil, to give liquidity to this big conglomerate, which was providing us this communication in many different countries. So in this manner, we had and we still have, and I'm not giving you the names and the more details because this is an ongoing proceeding. This is a very, very successful case with huge numbers, always bringing something unforeseen. But as I mentioned, this judicial supervision takes place since before the law. The law came last December, bringing us this the law becoming positive and UNCITRAL. And this is recognized globally as a law which is inspired on the principles of the United Nations. And the judge, when they approved this judicial recovery, this is inspired in these principles, which is established in the law of introduction of the Civil Code, to therefore bring legal certainty. So please note, today, if we participate in any doing business activity here in Brazil, which shows the good performance that we have in terms of the cross-border positivation in Law 11101, what they say is that it has this positive legal certainty. So I ask myself, how bold at that time it was for we to have here in Brazil, according to Chapter 15, a reorganization of this magnitude based on legal certainty. So some of people set forth that our law has universalism, others have post-universalism, but the fact is exactly what Judge Anglizé told us. Our law brings us a new interpretation of cooperation. This is an interpretation, this is something which is a consequence. And this is something which is relative to the corporate law, specifically to the law of insolvency. This is our specificity today, for us to have this legal certainty to show the world that we have an appropriate environment and a safe environment for us to be able to set up this reorganization, because capital no longer has that aspect. That's the only thing I'd like to take into account. This is a clear process. As I've mentioned, this is something which is still being looked at. This has been unfolding. The issue of a credit, of each credit having a legislation, takes away the idea of the principle of cooperation. And in some way, it removes the romanticism of this principle of cooperation, because in reality, it makes the preservation of a company vulnerable, and it's the magistrate that has to do this interpretation of what is court to court, of what is cooperation, above all for the informality brought by the law. It is not easy to negotiate credits that have totally different basis. And in reality, those are the values which become most important in the cross-border proceedings, to make the law of a creditor and the debtor, or of all other creditors, prevail. That is the secret. That is the challenge. This is very good. This is recognized, but I still visualize for us a huge challenge. We are just at the beginning of applying the transnational principles. I believe that Judge Kimball, who has a lot of experience in the US, which is the most traditional experience we have in Brazil, Judge Cristina also has some experience in order to contribute. But I can clearly tell you that here in my jurisdiction, the challenge we have ahead of us is to apply exactly these principles of cooperation, preserving our companies. And when I say ours, I say this because this is a cross-border issue. I have no doubt whatsoever of that. But the cooperation will truly happen in the sense that we can apply the law in a very harmonic manner. This is what I had to convey to you. This is my personal experience. I could go on here for much, much more time, but I believe the issue is, that's what I had to bring you. Thank you very much. Thank you, Dr. Monica. This case of OI, it's not only to bring innovation in cross-border insolvency, but also other aspects of mediation and everything that you have mentioned. And this is your activity in this case is what brought us to success. And I also thought it was very great for you to mention Carol and Bia. Definitely without them, we wouldn't be able to have such a brilliant event. I would now like to give the floor to Judge Kimball, who is a judge, a bankruptcy judge in the Southern District of Florida, who will be telling us some practical cases of applying the rules in the United States. Judge Kimball, please.
Good morning, everyone. Are you able to hear me clearly? Yes, very, very good. Thank you. First, I want to say how honored I was to be asked to participate in this morning's panel with my esteemed colleagues from Brazil and Colombia. I think today I must be an honorary woman in restructuring. And I also regret that my official portrait is nowhere near as beautiful as Judge Alina Mendez's portrait when you put yourself on, turn off your video. I think it would be useful before I jump into, that got a laugh, Alina, didn't it? Useful before I jump into practical considerations to give a little bit of historic background for the GIN guidelines. I was asked to focus on the guidelines that I think have been recently adopted in Brazil and which are adopted in many courts here in the United States, many of the bankruptcy courts here in the United States. But I think it's useful to put that in its historic context and address why we have them to begin with. The UNCITRAL model law, if you were to go back and look at the very beginning of the preamble to the model law, you would discover that the first listed objective is not to facilitate recognition of one insolvency proceeding in a particular country in other countries. It's not necessarily to facilitate the equal or equitable distribution of assets, for example. The very first objective is cooperation between courts of different countries. That was the starting principle of the model law. And there are several components of the model law that focus specifically on that. They are Articles 25, 26, and 27. And in the United States, we have those in 3 sections of the Bankruptcy Code, 1525, 1526, and 1527. The first thing that I would say, and this is the model law as enacted in more than 40 countries at this point, is that these provisions of the model law and the GIN guidelines that I will talk about a little bit in a moment are effective even before there is a recognition. They're effective in the United States and elsewhere when you have, even before recognition is requested and during the recognition process. So it's not necessary for there to be a formal recognition I'll talk about it from my point of view, for me to have recognized an insolvency proceeding in Brazil or the UK or wherever before we address the communication issues. It can happen during that process. Article 25 directs that the court in the enacting country is required to the maximum extent possible to communicate with foreign courts and foreign representatives. We often think of this communication as being between the 2 or multiple judges who are overseeing the various cases. But many times the communication takes place between the foreign representatives that may be involved in proceedings that are already pending in those countries. Article 25 specifically says that the court is entitled to communicate directly with not only other courts, but representatives, the representatives that are appointed in proceedings in other countries. And direct communication can be in a bunch of forms, and I'm going to go through that a little bit when we get to the GIN guidelines. Article 26 allows any court that's overseeing an insolvency proceeding that would be subject to the model law as implemented in that country to select somebody to act as the official representative of that case or that proceeding elsewhere. In the United States, that can be a trustee, it can be a debtor in possession, so the entity itself that remains under its management, but it can also be another person, such as an examiner, which is a type of officer appointed by the court in the United States to answer specific questions. Oftentimes, it is a forensic accountant. And then Article 27, and again, all of these things are enacted everywhere that the model law has been enacted, including Brazil. Article 27 gives a list a non-exclusive list, but a list of the types of communication that the court can authorize or direct. I can appoint a specific person to be in charge of communication, and I can do things such as require that person to give regular reports that would be filed in a case that I have pending with me. I can direct how the communication will be done, whether there will be public notice of communication, whether it will be done by telephone or video, whether there will be a website where data might be maintained, for example. I can also approve the agreements. Obviously, I can only approve them from the point of view of the case that I have pending before me, but I can require a foreign representative in a case that I have recognized, or any officer in a case that I have pending, to seek approval of any agreements that he or she might be involved in. I think at least in the United States, the model law as it has been enacted, which is very, very close to the model law, is unusual in one regard, and that is that it is rare for the United States to have a federal statute that directs that it is governed by law that is developed outside the United States, number one. So the model law is set up to encourage us to look to what all of my colleagues, for example, on this panel might be doing in cases, and to attempt to make what we do parallel to or to fit well with that. And in addition, it directs us to the guide to enactment. And for those of you who are involved in presenting cases, it's extremely important for you to read through the guide to enactment on anything that you do that involves application of the model law. But in particular, when you are thinking about what communication there might need to be between a case that you have in Brazil or Colombia or elsewhere, where you have to interact with another court in a foreign country. The guide to enactment has, if you look at paragraph 217, there are some specific provisions addressing how communication should be governed. Importantly, it says that you should take into account appropriate safeguards to protect both the substantive and procedural rights of creditors and other parties. In most instances, and I think this is fairly obvious, but the guide to enactment says it, communication should be done openly, meaning there shouldn't be secret communication, except with regard to purely procedural issues. It is actually okay for there to be direct communication between a judge in one overseeing a proceeding in one country and a judge overseeing a proceeding in another, to literally talk on the telephone about purely procedural matters. How does something get filed in your court? Who gets to file things? How do you set hearings? Things like that, perfectly fine. Anything beyond that, there should be some kind of advance notice to not just the representatives involved in presenting those matters to the court, but potentially to any creditor or other party that might be interested in what's happening in the court. The guide to enactment, that same paragraph, has a list, and again, it's a non-exclusive list, but a list of ways that communication happens between the courts that would be overseeing these cases. Obviously, I can enter an order, I can have a judgment, and I can direct that that be sent to the judge in another country. I can direct, for example, if there is a representative of a case pending in Brazil or in the UK or in Canada, I can direct that that representative make known to the courts in those countries in whatever way is appropriate orders that I have entered and the like. But that is not the only way that the communication can happen. It's perfectly acceptable to set up a Zoom meeting on notice to all parties so that communication about procedural matters can be addressed with everybody available. And that's where the GIN guidelines come in to provide some more specific guidelines on how you might address these concerns. Now, the Judicial Insolvency Network guidelines, which you can all find online, they do not have the power of a statute in the United States. We have in the United States 94 federal districts, and there is a bankruptcy court in each of those 94 districts. In fact, in terms of physical locations, there are often multiple locations within each of those districts. It is up to each individual bankruptcy court to determine whether they will adopt the GIN guidelines. Now, the Southern District of Florida adopted the GIN guidelines by administrative order back in February of 2018. I think that was shortly after the Southern District of New York had adopted them. They are not adopted in every district in the United States. Now, the reality is that you are most likely to interact with the Southern District in the United States, interact with the Southern District of New York, Delaware, and the Southern District of Florida in what we would call Chapter 15 cases. And each of those districts, of course, has the GIN guidelines in place. But if you were, for some reason, to seek recognition in North Dakota, they do not have the GIN guidelines enacted, and you would need to ask the court to enter a special order to implement guidelines like the GIN guidelines, or in fact the entire thing. And you should be aware of that. It is not a national implementation at this point. Now, the GIN guidelines specifically reference the parts of the model law that I was talking about earlier. But I want to walk briefly through, I'll do it quickly because there are 13 of them, but briefly through what each of the guidelines say and what I have seen in connection with implementation of those guidelines. But before I do that, there's really two things that happen in a Chapter 15 case, which as practitioners, you can be involved in. Many cases, of course, have unique aspects to them. You may seek recognition in the United States only because there is some real property in the United States that you need to have access to in order to administer a case that you have pending in Colombia or Brazil, for example. And so the nature of the communication that is important for that case might be different from a case where you have operating companies or had operating companies in multiple countries. And so one of the things that you can do is attempt to negotiate a form of protocol that's acceptable to the primary parties in your case and ask the court to approve that protocol by order. And that's something that you can do proactively. Most of my colleagues, including me, will not automatically approve an independent protocol for each case because we have the GIN guidelines and we can rely on those. But you may have instances where you feel the need to have some separate procedure. And for example, in one of my cases, I've actually done this in more than one case. I have asked the foreign representative to file regular reports about certain things that were happening in other countries where that foreign representative was also involved in insolvency proceedings, so that not just me personally, but anybody receiving notice in the United States would learn about those things without having to attempt to do a Google search. And also I have had at least one case where I have required information to be maintained on an independent website so that United States creditors would have access to that information on a regular basis. And there's very good reason to do that. Obviously, if you are administering a large case, the cost of communicating with creditors can be very high. In the United States, we have regularly approved systems in larger cases where there's initial notice to many people by mail, for example. and they are allowed to opt in to receive certain notices through a website or by email. And even if they haven't opted in, they have access and knowledge of that website so that they can access information. And back to the GIN guidelines, the first guideline requires the administrators in each of the countries to advise the court of developments that might affect those proceedings, and specifically says the court can require periodic reports. And I find that to be very helpful. I try not to create something that is an unnecessary burden, that is just made up work for the persons involved in the case. These cases are very expensive, and it can be flexible, but I think that is very useful. If I require reports, then that means they have satisfied their duty to advise the court. The second guideline says that I can create a protocol on my own, or I can do so after someone asks me to do it by motion. That's usually how it happens. I wouldn't normally come up with a communication protocol on my own. The GIN guidelines themselves are intended to provide the possibility for a variety of communication methods, but we don't always implement that in every case. If you do have a protocol, if you propose one, or if I were to impose one, the guideline number 3 says that it should address how you ask for approval of things. Many times there is the need for a representative to get approval in multiple courts for something because they have a duty in one country. For example, they might be in the main proceeding in Brazil, but then they may have property in the United States that they seek to sell, for example, and they would need to ask permission from me for that. And it is useful to have the protocol address those kinds of issues. The third guideline also says to address time-saving matters, and that can include electronic notice to creditors. It literally says that. But I would say that not just email opportunity. In the United States, you cannot supplant mail service with email unless you get a specific order or unless someone agrees. So it's very important to seek that relief if you need it. Guideline 7 talks about direct communication between the courts. And remember, the courts we are all just people. You're looking at a bunch of us right now, and we're humans, and we speak, and we have telephones, and we have the ability to talk by Zoom. We do not anymore need to communicate with each other solely by entering an order. But it's important that you think about how that communication might be helpful to the parties, and also to think about who would want to know that it's happening and what the parameters of the communication is. As I said, it is okay to have non-public communication, in my view, between two judges involved in a case that is cases that are related. But that should be limited to non-substantive matters, purely procedural issues. If the parties are affected, even if it means they're affected in terms of timing, or they are affected in terms of what kind of work they might need to do, they need to have notice ahead of time. But two-way communication by phone or video, now we all use video regularly. It's probably the one good outcome of the pandemic. We're very used to it. That is extremely helpful in Chapter 15 cases. I remember even 2 years ago, people would fly from Paris for a hearing when they don't need to do that. They can appear by video, and it makes a lot of sense to use the technology we have. So when you have communications that have been made public, I find it is useful to have them what we would call on the record, meaning I'm in the courtroom, it's recorded, and a transcript is made available. In the United States, I think you would find it very unlikely that any of my colleagues would have certainly any communication involving a substantive matter, and even on procedural matters after notice and parties present, they would not have a transcript prepared. We don't, you might be surprised to learn, we don't automatically produce a transcript, but the recording is available and you can always get one. And once it's ordered by anyone, it goes in the docket in our case. The guideline 10, I'm going to jump ahead to guideline over a few guidelines. It says the court can authorize a party to appear in another court. Now, obviously, I cannot say to one of my colleagues in Brazil, you are required to recognize and listen to whoever I might send. The purpose of this provision is so that I can identify someone who the other court can rely on as being someone who is authorized to speak. And so it is us giving an imprimatur to that person. It isn't requiring another court to listen to them. You may have your own rules of standing that govern who can be heard. I think guideline 11 is very rarely used, but I think it can be very useful. It permits me or any court to hear a foreign party without them becoming subject to the jurisdiction of my court. I can enter an order saying, you may come and be heard, but you will not be subject to being sued, etc. in the United States. I think that probably the one matter that I don't want to go into this too much because we don't have enough time to address it in detail. But if you look at Annex A to the GIN guidelines, it addresses the possibility of there being joint hearings. And we have had, I think, only one, and Lisa can't speak right now, so she cannot join in. But I believe we have had one joint hearing that involved Judge Mark, who some of you have met at previous presentations. But Annex A talks about having joint hearings. So from the point of view of a United States judge, one of the difficulties that we have is that the rules in the United States are set up so that it is unusual for somebody to testify at a hearing and not be physically with me in the same room. There is very little law on this in the context of Chapter 15. It is my view that it is okay for me to accept testimony by video when it is a simultaneous hearing and it will be impossible for that person to be in more than one place at the same time. And so in my view, that actually satisfies our requirements. But that is one of the issues you need to address if you are setting up a protocol for a joint hearing. And from my point of view, there's nothing magical about a joint hearing. I'm having a hearing and the hearing happens to also be occurring in front of another court. I think the difficulty in setting up the protocol on a practical level is how we deal with things like evidentiary objections, for example. It's different here than it is in Brazil. And so you need to have a lot more time to make your presentation than you would if you were doing it with just one court, because you may need to address procedural or evidentiary matters twice in connection with everything that happens in such a hearing. Some of those issues are addressed in Annex A to the GIN guidelines. I think that there is no universal set of rules that you can come up with, because each of those hearings is going to be very different. Let me point out that one thing that I think is probably never done in a joint hearing, and that is recognition, because recognition is always done, although the rules are uniform, is always done from the point of view of the recognizing court. Usually these hearings will have to do with the approval of multi-party settlements, or the approval of sale of assets that implicate multiple jurisdictions. Those are the kinds of cases that will require joint hearings, and you need some lead time to figure out what your rules will be for those hearings. I don't think I have anything else to add at this point. Again, I want to thank you for inviting me. We do have, you could have invited somebody else, but Leza apparently latched onto me. I hope that was helpful. Thank you.
Obrigado, Judge Kimball. Foram maravilhosas suas palavras.
Thank you, Judge Kimball. Your words were wonderful. They gave us a perspective about this novelty that was implemented in Brazil such a short time ago. Thank you for your kindness at the beginning of your speech. Thanks for that. And now I'll quickly give the floor to the next speaker, which is Appeals Court Judge Monica Zucchi from the Court of Justice of São Paulo. She'll tell us about the reality of Brazilian insolvency processes before the consolidation of GEN. Thank you, dear Eleni. I'd just like to say that I was really honored to see my name pronounced right after Dr. Monica's name. I am Maria Cristina Zucchi, and it is an honor to participate in this event, this webinar. I'm really happy. The insolvency subject has been the object of studies, and I'm truly passionate about it for many years now. I've always been teaching about bankruptcy and now reorganization. And I've been constantly studying about it and trying to understand with the rules of reorganization and bankruptcy. I'd like to greet all of the organizers of the event for the wonderful idea they had to set up this seminar. And from what I saw today, I'd also like to congratulate those who preceded me, Dr. Monica, Dr. Anglesey, and Judge Kimball, who also spoke about the reality brought to us in the world today through the adoption of the GEN and the model law, which have been extremely valuable. Actually, if we want for Brazil to be understood for what it did with bankruptcy and generally speaking with transnational insolvency, so far, we cannot simply place a historical milestone and say that there was a time before the formal adoption of the ancestral law and after the adoption of the model law and the GEM. We have to discuss a bit further if we want to understand what Brazil did in terms of transnational insolvency. And we start this analysis seeing that initially transnational insolvency was regulated in our law by a private international law as an international law rule with all of the limitations that those rules brought about by Decree 6982 from 1878. And we had that regulation up until 1980 when they came up with the decree that brought into itself the regulation of bankruptcy and international insolvency. Then the subject was transported into the law that specifically dealt with insolvency, international insolvency matters. And we saw an advance in that regard. After that, the civil code process from 1939 was enacted, also regulating the subject. So the focus that had been taken to a specific area of international insolvency and bankruptcy law also started to be regulated within the procedural level, which brought about consequences because one of the articles brought about by that was that foreign rulings stating that Brazilian owner residing in Brazil is has gone bankrupt is not applicable. So it was not accepted if the business owner resided in Brazil. And of course, if that referred to assets located abroad. Of course, not too long after that, the Supreme Court ruled that it was unconstitutional. So our problems occurred by us trying to make adjustments to the regulation of international insolvency. After the code from 1939, it was revoked, as we know, by the new procedural code from 1973, which simply said nothing about international insolvency. Along that path, there was the enactment of a decree from 1945, which was our bankruptcy law and remained so for 60 years in Brazil. And that decree that came into force in 1945 had one article only that would be applicable to international insolvency, which was Article 7, which said, is competent to state insolvency judge in whose jurisdiction the debtor is established with its main company. So in our insolvency system, we saw the implementation of the broad concept of the main business or main companies that has led to so many discussions and to so many changes of decisions. That article was kept in force, and based on it, some decisions were made in Brazil with a tendency to accept or receive the effects of a declaration of bankruptcy outside of Brazil. This absence of a regulation in the Civil Proceedings Code is also justified because the Supreme Court had, up until then, the competency to approve decisions, court decisions, stating that there had been a bankruptcy abroad, and with that competency, the subject was then treated in the internal rules of the Supreme Court. After that, as of 2004, that competency was then transferred to the Superior Court of Justice, which did not add anything to its internal rule about the subject. So we see that in Brazil, we had huge difficulties in the sense that there was an absence of regulation, and also in the sense of failure to accurately define the competency for the courts that had to decide on aspects related to transnational insolvency. Therefore, the jurisdictional competency got transferred to the Superior Court of Justice. After that, we then had civil proceeding that was totally silent about the subject. And even when the law of introduction to Brazilian legal norms was enacted by a decree from 1942, which brought provisions about the competency to judge and decide on foreign proceedings, that still did not give us any solution. And then in 2015, we had the new bankruptcy law. And that new bankruptcy law was also repeating Article 7 from the previous decree, repeated the same concept, saying that to declare and recognize insolvency, both in terms of reorganization, judicially and extrajudicially, the competency lies with the judge located in the location where the debtor has its main business address. And like Dr. Monica mentioned in her words. Then in 2015, we then also saw the enactment of a new civil proceedings code that gave us two types of support in regulating international insolvency. In Article 67, it states that the agencies of the judiciary must cooperate and collaborate in solving proceedings with reflexes or which are the results or reflexes of international proceedings. That according to Article 67 of the new Civil Proceedings Code, and Articles 960 and 961 talking about the possibility of a letter as a formal requirement to determine the execuability of international decisions in Brazil, and therefore by requiring the formality of a letter rogatory, that's what it stated. And in the meantime, Brazil started seeing cases of international insolvency. And I chose three examples: the cases of Sete Brazil, the cases of Grupo Oi, and the case of Group OGX. And the reorganizations of companies as Seven Brazil and the OGX group, the international partnerships were simply excluded from the proceedings based on the territorial perspective. Well, that is based on Article 3rd of the law of bankruptcy, which has always been interpreted as the predominant adoption of the theory of territorialism in insolvency. However, this exclusion of international companies was reviewed, and the partnerships went back to their initial reorganizations, which encompasses the current perspective of a universal synergy between partnerships belonging to the same group, which was a huge progress, but that was an individual effort by the judges that attempted to find a greater meaning to justify the inclusion of foreign companies in their reorganization processes. As for the reorganization of Group Oi, there was an active consortium of 7 companies in the group, including 2 international partnerships present located in the Netherlands. As mentioned before, the proceedings were recognized in England, States, and in Portugal. However, there was a request for bankruptcy from the international partnerships made to the court in Netherlands, and it went on simultaneously to the proceedings in Brazil. With that, the Court of Justice of Rio de Janeiro, and Dr. Monica, once again, greetings to you, understood that international partnerships were mere financial vehicles and that the Brazilian decisions should produce their effects, including in foreign territories. After the approval of the plan for the Group Oi in Brazil, plans of composition were also approved in the Netherlands to be complied with internationally. So our judges already tended towards advancing towards the acceptance of bankruptcies recognized abroad in an attempt to walk hand in hand within international courts. As extensively discussed this morning, the law from December 2020 brought into our bankruptcy law the model law. So a new chapter was included. That was chapter 6A, which mentioned 25 articles dealing with transnational insolvency within our bankruptcy law. So we can say that our Supreme Court and the Superior Court of Justice systematically, in the few cases we had, and evidently due to this lack of regulation, these few cases, it's easy to understand why there are so few, but our superior courts have always tended to refuse the approval of international decisions ruling insolvency, understanding that there would be a violation to the national sovereignty, and that was the decision that was predominant in the 1980s. For instance, the Supreme Court refused the approval of an agreement approved in creditors' assembly in a case of German insolvency due to the non-presentation of an approval from the international parties. And our Supreme Court also understood that the agreement could not in any case produce effects in Brazil because it dealt with assets located in Brazil, which should be dealt with exclusively by the Brazilian justice. Therefore, all that contributed to the panel that we've had all this time till the moment when the model law was brought into our specific legislation. And the system that was included in our law, we can say in a very short manner that it's based on 4 pillars, based on principle. The first of which is to facilitate access to international jurisdictions. So you open the doors to representatives of international proceedings. You open the doors to creditors and debtors that are facing insolvency proceedings abroad, regardless of court decision, with the possibility of requesting that measures be taken by the Brazilian jurisdiction. And therefore, our measures would be made in favor of the proceedings. Second pillar, facilitating the recognition of international decisions, trying to become more informal and expedite this acceptance, looking for one of the principles of our bankruptcy principle, which is of trying to deal with the debtor's assets in the most isonomic, egalitarian way between creditors, respecting the par condicio creditorium. Third pillar, the possibility of measures to assist by the local court as a temporary measure or after the recognition of the international proceedings. And lastly, the fourth pillar of the system that was brought into our law is the cooperation between courts where the assets are located and the coordination of the proceedings. So how to establish this communication? Judge Kimball explained very clear to us. Our courts are evolving, and appeals court judge Monica also mentioned that in a panel showing how much we have evolved and how much we still have to evolve. And also, like Dr. Anglizé said, we already saw how the mindset of our judges is ready to receive, understand, and expedite that process, putting these novelties into operation. And in Brazil, all of that was accepted by the National Council of Justice. If you're not from here, it's an entity that's part of the Brazilian legal system that was created by Constitutional Amendment number 45 from 2004, that is really an agency that provides for a greater cohesion across the different entities of the Brazilian legal system. And that agency promptly regulated the subject of transnational insolvency through a resolution 394 that was enacted on May 28th, 2021. That, Judge Kimball, is the Brazilian norm that implemented GIN lines from the Judicial Insolvency Network. So it really brought and internalized, as we frequently say, these guidelines established by GIN, and we are now working under this regulation in the Brazilian judiciary. So insolvency protocols, procedures for hearings, and in all stages of the process, communication between judges with the purpose of achieving greater efficiency and reducing costs in general. Undoubtedly, that is the way forward. And the never before seen case that we had in this context, that was the case of the judge that was mentioned by Dr. Monica, that granted the anticipation to the Prozaf company to recognize the existence of the insolvency proceedings of the company in Singapore once the legal requirements had been complied with. And in conclusion, I brought from my court, São Paulo, both from the first and the second levels, where we have business chambers that are specific to analyze and judge the international insolvency cases. We have a decision from March 2021 made by then judge that unfortunately left us to proceed with his career in the academy, Dr. Marcelo Sacramone, who refused a request of decision recognition simply because the request itself was not formulated. So due to the absence of the request, that ended up being refused by my former student, my dear Marcelo Sacramone. And our business chamber decided, for instance, in February, under the umbrella of the new bankruptcy law, it decided that it would maintain the requirements for the continuity of an ancillary procedure as discussed by the General Assembly of Creditors in relation to the debtor at issue, therefore maintaining the need for and the efficiency of an ancillary proceeding to collaborate with ongoing foreign proceedings. That decision was made by our colleague Zubanishi, and I'm also going to mention a decision made by Judge Ricardo Negrão from April 2021, where he says that the effects of the new reorganization plan are subject to the control of legality to guarantee transparency and legal security, even though it is related to decisions that precede the law 2012 from 2015, since the submission of Chapter 15 was a condition for the adjustments made to the reorganization plan. The new renegotiation approved by the Brazilian law must be submitted to the North American court, therefore ensuring the consolidation of transnational economic relations. And he then approved that in that sense, because the debtor did not want to take this subject to the court, if I'm not mistaken, of New York, and therefore refusing that. And he wanted it to be restricted to Brazil, which would be, of course, would make no sense after all of the progress that was made by our law. And lastly, I want to mention one last decision by our appeals court, where it discusses what it is to what it means to accept the foreign proceeding, which is not the same as approving of a foreign decision, making therefore a difference, not only taking into account what's stated in Article 667A, which confirms the competency of the Superior Court of Justice in deciding about the approval of international decisions as established by Article 105 of the Federal Constitution, but also highlighting the provisions of Article 167D of the new law, which does not mean that you're denying that competency. And therefore, we need to make a distinction between recognizing insolvency internationally on the one hand and approving an international decision on the other. Hopefully, I was able to mention aspects that were sufficiently able to give you a good idea of Brazil's situation before and after the adoption of the GEN guidelines and the model law. Thank you. Thank you, Dr. Maria Cristina. You're always giving us brilliant words, not only bringing us updates, but also the history of systems, always welcome. And I'll now give the floor to Dr. Susana Arango from Colombia, who will tell us about the protocol of recognition of the LATAM process that occurred in Colombia. Doctor, you have the floor.
Thank you very much. Thank you to IWIRC Brazil, to the President Liv Machado and Leisa Blanco, Chair of IWIRC. I'm also part of this network and I'm very happy to be part of this event. And thank you to my outstanding co-panelists for sharing this space. So Colombia adopted the cross-border insolvency model law, the UNCITRAL model law. So this was done in Law 1116 of 2006. So far, in more than 15 years, Colombia has had less than 10 cross-border insolvency cases. I could just mention Quebec, Stanford, Urbe Global Physical Services, Pacific, the LATAM case that I'm going to refer soon, and Italtel. So the use of these mechanisms has been limited yet. Thus, this doesn't mean that Colombia is not open or has not the legal frame to use them. So as Judge Kimball was saying, the pandemic probably accelerated the revelation of some paradigms, like today's normal to communicate using these platforms instead of the traditional mechanisms. And this makes communication before insolvency proceedings and these tools even more relevant, because these allow us to directly communicate with other courts. So the legal systems have also been evolving probably in the same way with this pandemic. The countries took the opportunity to update their bankruptcy systems. So I believe that we are going through the same path, and that's something that we could say is good from the opportunity given by the pandemic. So the LATAM case is an ongoing case. This is an airline group based in Chile, and this group is going through a Chapter 11 proceeding in the US. So these Chapter 11 proceedings seek recognition in different countries, in Chile and in Colombia as well. I'm going to speak from the Colombian point of view, this proceeding was recognized as a principal foreign insolvency proceeding. This means that, generally speaking, the Colombian court will let the US court manage the main issues of the proceeding, and then when some decisions need to be applied in Colombia, this will be reviewed by the Colombian bankruptcy court. So with the recognition, then the Colombian court granted the automatic measures, and it also ordered the continuation of some executory contracts, so they are not terminated in the country. Moreover, the foreign representative requested the approval of a communication protocol between courts. So I would say that this is the first time that a protocol is approved in a Colombian case, because there could be other protocols between the legal representatives or the foreign representatives, but not a court-to-court protocol. So this protocol was approved and is based, as Judge Kimball was mentioning, well, the gene guidelines have not been approved in all the courts in the US, but the Chapter 11 is being handled in the South District of New York. So the protocol, the gene protocol or guidelines have been approved by that specific court. Then the protocol subject to approval in this specific cross-border insolvency matter incorporates the General Order M511, which is the one that approved the guideline. So this protocol was approved also by Colombia and also by the Chilean court. Actually, the Colombian law that incorporated the model law allows the courts to be part of protocols that is specifically stated in Law 1116. Then that's a way in the where the courts can cooperate with other courts. So this is the first time that a protocol is in place. It hasn't been used so far with regards to specific matters, such as handling joint hearings, for instance. Maybe it's because this was done very recently. So this order, or the order issued by the US court, specifically mentions that the protocol is limited to procedural matters, that this will not be in prejudice of substantial issues that are held by each jurisdiction. So each jurisdiction will keep its powers with regards to the procedures that are being handled in each country. Of course, the protocol will not limit the powers of the courts that are part of these guidelines. And this has the purpose of making it easier to communicate and, of course, to share information. So there are some confidentiality obligations. So the courts can even communicate and make this communication not absolutely public to the parties, but there are also some guides so on the way to make this public when they are going to be hearings held in a joint way. However, in this case, it doesn't seem to be very likely to have joint hearings because, as I mentioned, Colombia recognized the US proceeding as a principal foreign insolvency proceeding. So in the Colombian case, there are usually not very substantial issues being subject to study by the court. There are some references to the model law saying that when we speak about parallel proceedings, is not the same because the gene guidelines have other reach of this type of wording, and this allows as well to keep exclusive jurisdiction over the specific matters. And I hope this is just the beginning and the way to open the door to more communication between the courts. I would just mention another case where it's called Italtel. It comes from Italy. So this is a case where the Milan tribunal asked for recognition of the proceeding, of insolvency proceeding of Italtel. There, the Colombian court recognized this foreign proceeding, and the foreign court asked the Colombian court to put on notice what was going to be done in the foreign proceeding. So the Colombian court, in cooperation, served this to the public and actually invited the Colombian creditors to be part of the Italian proceeding. So I would just say as a conclusion that although we have not had many cases to build a strong tradition on cross-border communication and cooperation in insolvency cases, Colombia has the legal frame and the reliability to put in place mechanisms to communicate court to court, even without the incorporation of the gene guidelines, and even with countries that have not incorporated the UNCITRAL model law, such as Italy. So that would be the Colombian perspective. I believe that we do not have a lot of time, but of course, any questions are welcome.
Obrigada, doutora Suzana, pela participação.
Thank you, Dr. Suzana, for your participation. We actually had lots of things to talk about, but we're short on time. So I'd like, with that, to wrap up and end the panel, thanking once again our panelists, and give the floor to Diana. Thank you, Eleni. Thank you, everyone. The panel was really excellent, with huge learnings. Thank you very much for all of you who participated and shared your knowledge. Before we have a short break to move to our second panel, I'd just like to remind you that Dr. Liv Machado, the president of IWIRC Brazil, said at the beginning, at the end of our panels, we'll give out a book and our IWIRC kit with the gin bottle and the glass as well. So don't miss out. In a few minutes, we're going to be back. Thank you.
Be inspired. Onde tudo começou. O IWIRC foi fundado em dezembro de 1993 por Celina Melnick, uma advogada, Lauren Ryan, uma analista financeira, e Marta Fettner, uma banqueira de investimento, para capacitar e encorajar as mulheres no campo da insolvência. Os primeiros membros aderiram
Hello, everyone. Thank you for waiting for these minutes. And now we'll start our third and last panel of the day about debt financing. And we'll have Dr. Beatriz Faneca, a partner with Faneca Lawyers, and at-large director for IWIRC International, Dr. Joanna Bontempo, consulting partner in charge of the reorganization of CSMV lawyers companies, Dr. Fabiana Solano, the partner of Felsberg Lawyers, Dr. Ming Dong, a partner of Junhee LLP and a member of IWIRC China, and Dr. Rosa Maria Rojas Verdes, a professor at ITAM, specializing in insolvency law and a member of IWIRC Latin America. Now I'll give the floor to our moderator, Dr. Beatriz, who will start our last panel. I wish you a great panel. You're on mute. Good morning. Thank you, Diana, for the kind introduction. I'd like to thank the board of directors of IWIRC for the invitation to be here among such highly qualified professionals. It's really a privilege to be here. Without any further ado, I would like to show you the topic of this panel, which is debt financing, which is almost like a myth, the idea of giving money to a company that is in a stressful situation for it to recover. Without further ado, I'll invite our dear Joanna, and she'll speak about the subject. Thank you. First, I'd like to congratulate IWIRC Brazil on the Congress. And thank you for the privilege of being part of this panel with such amazing professionals that I admire so much. So I'd like to thank you and say that it's a pleasure to share this panel with all of you. As Bia said, I was given the task of talking about deep financing in Brazil. The most frequent problem of debtors is access to new money. As people say, there is no recovery without new money, and new money needs to be specified. So it needs to be priced and priceable. What investors do not tolerate is insecurity, legal insecurity. You cannot put a price on insecurity adequately, at least. So ideally, for there to be investment in situations of stress, the bankruptcy system must ensure to the investor that's placing a bet on the recovery of the debtor and believes that they'll recover, that they can see efficient paths and give privileges to the investor in practical terms. The legislation must work in practice so that investors are able to recover their investment in a scenario of stress or bankruptcy, if it happens, where and that they are able to get a return from their investment. So the reorganization process must be effective and must be given priority and must be agile. The Brazilian bankruptcy law addressed that in a very mild manner in terms of financing given to debtors. That was provided for with only two benefits for financiers or sponsors, applicable only in case of bankruptcy. First, the investor would be paid with priority in case of bankruptcy, but that was highly discussable and controversial. The advantages were not clear. Some other parties would also have other benefits above those of the investor. And the second advantage given to the investor is if they're a pre-existing creditor, the credit would be reclassified to a general privilege in case of bankruptcy. So it was not really substantial incentives, and they could only be captured after bankruptcy. So we had a series of other problems related to recovering the investor's credit after bankruptcy. Bankruptcy was a highly uncertain and long procedure where you can't tell exactly when you're going to recover the assets and so forth. So there were not too many DIP hypotheses. We only heard about a few cases of DIP in these first few years, and only cases with fiduciary guarantee, which is a guarantee that ensures that the investor will get their assets back in case of bankruptcy. So it gets paid with an asset without having to go into a creditor's line. But before the reform went into force, in the beginning of 2021, with the introduction of the alterations brought about by the law, the legislation was changed and advanced in several aspects, especially when it comes to the DIP and classification, and legal security was provided after this alteration. And that is reflected in the number of cases of funding that we've been seeing that have been authorized and are being considered, and also the amounts involved, especially in terms of what's positive for the market. Certainly, there is a relevance in the financial market, and however, we still have some cloudy aspects that were not addressed by the reform or that came up due to the reform, and they should also be addressed by our sector. But basically what the reform did was it dedicated a specific section to the law to deal with the DIP. Even though the wording of the articles is confusing, the rule of financing has not been excluded. So you have a duplicity of norms that leads to a certain confusion as well. But in summary, the law now defines that about the DIP, that the reorganization judge must authorize the funding guaranteed by the assets of the debtor or third parties. And this building, this asset has a super priority, as it were, because it's going to be the second creditor in the order of payments, whereas the other types of funding for the debtor will be classified according, will be given the fifth priority in the order of creditors in case of bankruptcy. And that does not necessarily require legal authorization. And here's where the first questions come from, because what type of contract would be necessary? Is it only as stated by the law, or could we have commercial credits as well, such as, for instance, payment in installments? Should we use DIPs guaranteed by assets and non-circulating assets? Or could we also consider the current assets? We've seen cases where DIPs are being authorized as the second order of payment in case of bankruptcy, with the guarantee of current assets. But would they have the same priority in case of bankruptcy just because it was authorized by the judge? To what extent could that be seen as a benefit versus the other creditors that did not look for these benefits because it was not necessary, because it was not related to non-current assets? So wouldn't that be a violation to the quality of creditors? And to what extent looking for a judicial authorization just to get the stamp of a judicial authorization wouldn't alter the nature of the DIP or not? Or is it only a matter of giving comforts to creditors and does not change the order of payments? So it's a series of questions that start appearing as a result of this law that will have to be faced by the doctrine and the jurisprudence if the debtor goes bankrupt in the future. Another very relevant aspect brought about by the law, which is very positive for investors, is that it gave investors the expeditiousness in the use of DIPs. This brings stability to the decision and prevents appeals from changing the DIPs guarantees. That's undoubtedly a progress in terms of legal security. In the past, we had DIPs that were signed, granted, or negotiated, and resources that would subvert the rationale of the proceedings, and the investor would then give up on the negotiation. But one very relevant aspect is that in this specific case, stability is not unconditional. It only deals with the DIPS guarantees. So, of course, nothing prevents other aspects related to the DIP from being challenged, such as, for instance, the interest or the way the DIP was negotiated, or the possibility of other creditors being included in the DIP. There's a series of other aspects that could be challenged in addition to the DIP's guarantee. And in theory, one could question these specific aspects of the law. And another aspect, which is quite controversial as well, is the participation of creditors. Many decisions have been made without any orders being issued to the creditors. And after the payment, this decision becomes stable, and creditors no longer have the possibility of appealing from that decision before the payment. So it would be prudent, so to speak, to wait for the disbursements to be made so that you can rule out any discussions about not giving the possibility to creditors participating in the process, and at least to provide for a higher level of security in that regard. Another aspect that the law mentions is about the subordinate guarantee, which is very interesting, even though I don't think that's going to be very useful, because there are certain limitations about the effective guarantee. If, according to the first guarantee, if the recovery is considered due, it's possible that the investor, which is not subject to reorganization, will not discuss or question the assets. So it's a mechanism that in practice only works in cases of bankruptcy. And the order, in which case the order of guarantees will come second to the order of payments of credits. So that was a legal provision of subordinate guarantee that, first, we don't know if it will happen, and there's a lot of discussions about the amount involved in the guarantee, but in practical terms, it seems to me that it makes no sense for it to be used. And it seems to me that the law failed in not, or was too mild in not adopting the mechanisms of US legislation that deals with the possibility of giving priority to the guarantees. And in that case, I believe it would be much more relevant for you to give priority guarantees because our legal practice shows that in most cases, the assets are already involved, and you really have to constitute the assets are non-current, and you have to give relevant guarantees that for the creditors, ensuring that those creditors that were guaranteed by that asset, that they're going to have similar conditions as long as the judge so rules. And I believe that here's where the law was not did not follow the lines that the doctrine expected.
I know my time is nearly up here on the controversy regarding the funding by the partners or members of the debtors. This is a possibility which was considered here. In reality, we never had this restriction of the funding by whoever it may be. What existed was an idea that the funding by the partner or any of the debtors would have a subordinate credit, and that would reduce the incentive to a great extent for these players to make any type of investment in the scenario of the insolvency for the debtor. But in practice, what we have seen with this reform is that the money, it doesn't matter where it comes from. What happens is that despite this, there's a controversy because it is necessary in one way or another for the debtor to prove that they've sought the best investment opportunity and how to guarantee that they have done this when the partners or one of the debtors is a financer, when this investment could be done through equities. This is something which is a very delicate issue. We can already see this in practice happening, but it is important to demonstrate that the investment is being done by conditions which would be appropriate for the market, which they are seeking market alternatives if possible, and that is something which is compatible when they observe the market practices, and that they observe the principle and that this is something which should be guiding all the relationships between the parties. I believe that we only need to be slightly careful because historically, credits involving partners of a group have always been used, or many times have been used, for fraud or things of this nature. Therefore, the last thing we need is for these movements to be shadowing the judiciary or covered by the judiciary and for all of our creditors. So this is the lack of trust which exists. But I think what is necessary is that we have a historical examination of injecting resources in the possibility of inputting capital and resources through a capital, analyzing all the efforts which were being put into force by the debtor to in fact obtain other funding and alternatives which are more economic, to see the specific options that exist of the funding, the interest rates, payment terms, the guarantees, if they are truly compatible, in order to be able to verify that the funding which is being suggested by one of the debtors truly is an appropriate alternative for the company's reorganization. So I believe that despite this analysis is not explicit, but this analysis isn't something explicitly set forth by the law, it is very relevant to truly avoid that fraud happens. I believe we could spend hours here talking about this, but we have other colleagues who will be dealing with the concrete cases and other more relevant aspects, and also in comparison with the other legal frameworks. So let me give you the floor back for you to be able to make your comments and to continue. Thank you very much. Thank you very much for your fantastic presentation, which was very good. And the issues which we're going to be looking at here is going to be a case-by-case analysis of a practical case and involve the collaboration of everyone involved. And now talking about everyone involved, I would like to invite our dear friend Fabi, who has always been involved in this kind of procedure, even before the model law being enacted, for you to share a bit of your experience with us. What was the enactment of the law? What will change now with the law, and what can you expect in the near future? Thank you, Fabi. The floor is yours. Bia, thank you very much. I'm going to try to stick to the 15 minutes that we have, as I know that we have international stars to speak, and I'd really like to listen to them. So initially, I would like, first of all, to say a special thank you to Liv, Bia, Tatiana Flores, for the incredible work, and for everyone involved in the IWIRC activities, which is truly incredible. I think in the field of insolvency, insolvency has always been traditionally a very male field in law and from the financial standpoint. And here in Brazil, we have seen the development of the female community with many different representatives, and IWIRC has joined this, has taken this cause on, and has been promoting an opportunity for women to voice their opinions and concerns. So congratulations. The last time I was looking at the history of IWIRC, the last event I went before the pandemic was the Congress in Rio. I have been in lockdown since the day after, and that's happened to date. So this is just an idea of today's event. Joana started very well talking to us about some points which really touch my heart. And what are they in the Brazilian legislation? There's a sentence which summarizes everything, which is a case of legal certainty. So reforming this law, the way in which it is being done, this is something which is done in a good manner, and looking at the creditors and investors and for the social function of a company and pro-debtor, and to reallocate the assets of the economy and a rational use of that, and always an increase in the economy and of the national GDP. So the idea, I believe, behind insolvency is to take value of an insolvent company and to maximize this value, to once again bring that company with a lot of effort to the company. So in this sense, I think there's no, when a company is in a financial difficulty, let me just keep track of the time here, wait a second. So there'll be two possibilities. They'll either start a reorganization, reduce their debt with third parties to reorganize and to restructure that capital structure that they have, or they will sell assets and to transform that product or product of those sales into creditors, or they're going to get the money in the market. And the problems were many, and the dip in the former law was extremely wrong. And we had examples which were not very successful, as is the case of the OAS, which was a very extensive process of a company called OAS, which at the end didn't work. And then the NOAA law came and told us that this is a very good initiative, which is something that everyone wanted to drive this mode of funding to be recognized as something essential. And that's what was done. And this was done inserting a new article, a new session in the chapter of the law that deals with the recovery, which is section 4A, where they have a series of Article 69 divided into A, B, C, etc., where they have all these rules of the deep financing. And the market has been reacting in a very positive manner to that. So I see in the office where we represent debtors, but not only debtors, but also investors, where there's a warming up and the time which is in fashion now, which is deep financing in Brazil. So this is a big success of the law. And I think we need to congratulate all these legislative efforts which existed to put this into practice. And what Joanna has mentioned at this time is that there are issues which are worrisome, which are things which come from talking with a legislator about some of the topics which are essential for us to define deep financing. And we who are operators of law, or not only attorneys, but judges included, we have the very bad task of having to understand everything which was mentioned in the law in a way which is rational and that gives legal certainty and which makes the Deep Financing Institute work. But I think this can bring us certain traps, and these traps are troublesome. So to start off, despite all of us looking at this, and I'm sure that this is not an opinion of mine alone, there's many different requests in law, etc. And looking at the possibility of giving a deep for the debtor, they are very big. This is the new. But the problems come afterwards. The problems haven't all appeared. They start to be shown, they start to be observed now. So what is the big problem here? The big problem, as Jana mentioned, is that before we had a deep financing, which was regulated by another article, which is Article 67, which placed all debts, or no, better said, sorry, which placed all the, look, sorry, I'm making mistakes here. Well, yes, obviously done during the reorganization process on the order of priorities in terms of the bankruptcy, which are bigger or better than the others.
What happens is this new section of debt financing was regulated by Section 4A, but Article 67 is still there. So it means that because the possibility of loan through 67 is still in place. And actually more than that, loans, according to Article 67, are dealt differently in bankruptcy. The order of priorities is there. It's in fifth among the creditors, according to Article 34, 1E. But the super dip that's in Section 4A has a higher order of priority. It comes second in the general order of payments. So what happens is it is paid by Article 84, 1B, and above it, there's only labor monies that are limited. So there is an effective security that the super dip will be received. But how do we combine these two things? And it seems that the questions are extremely important. The new DIP regulated by Section 4A, we're talking about three requirements. First, you do need a legal authorization, which was not required before that. In the DIP regulated by Article 67, you do not necessarily need a judicial authorization. And the guarantee of non-circulating assets, which means, for instance, that the other loans made during the reorganization that are clean or guaranteed by the current assets would still be regulated by Article 67 and would therefore have a lower order of priority, even better than the creditors, but lower than the super dip that's there as second in the order of priority. And the purpose that Joanna mentioned, but the purpose, I think, in my opinion, was not well defined by the legislator because it's too broad. Purpose encompasses everything. And even if I want to expand the activity, that is still a reorganization measure. So that's less important. But these two first requirements, which are the legal authorization and the guarantee of non-current assets, it seems according to the wording of the legislation, it seems to be very clear the sense that this is what defines the new DIP. And many could challenge the fact that this differentiation of super dip, why should we restrict the guarantee of assets to the non-current assets of the debtor? Is that a fair criterion? Does it make sense? Or has the legislator made a mistake? And the problem of the legislator making a mistake, and I go back to Joanna's initial sentence, is a legal security. So inside this margin and within these problems of legal uncertainty, how do we act, and how should the judges act? First, I think that we should be careful in our study of the law, and being careful in studying the law, of course, brings intransposable barriers. But should I say that the legislator did not mean that? And it's crazy because it's complicated because you can simply ignore a requirement of the law to adjust yourself to what we understand as a function of the DIP, which is to help the debtor or the recovery of the company. But to what extent can we interfere in what the legislator says? In practical cases, and I want to talk briefly about that, it's important that we know that I think that when the law changes, the change comes first in reality, and in practice, we just adopt that, and that's only consolidated by the law. I had two experiences with the DIP before the change of law in January that were paradigms. The case of Renova that involved the DIP of one of the shareholders and another DIP. And the first DIP was annulled by the first instance judge under the assumption that the shareholders needed to make capital for the company. And since the company was insolvent, that would be under capitalization. And that was reverted, in my opinion, by the court correctly. Otherwise, we won't have limited responsibility partners anymore. There would be a permanent obligation for the shareholder to capitalize that company. When the shareholders themselves, they're also oftentimes solid companies with their own obligations, and the obligation to not go into a high-risk investment. They have their fiduciary duties onto their own shareholders in the upper levels. And the law is here to solve this problem. The second dip, which was a market dip, was provided for in the plan, and I do not have time to talk about that in detail, but I just want to talk about some problems that I imagine will happen. In the case of Samarco, what we've been seeing already, and in my opinion, this is directly opposite to what is in the law today. We see dips being granted without guarantees of the non-current assets. There was an attempted dip in the case of Samarco recently by the shareholder. And one of the things I want to say is that, as opposed to what Joanna said, I think that a dip with a shareholder is very interesting because it is cheap money, and it's likely that it is the least expensive money that you're going to have, because the funds charge and charge a lot. So I think that in the case of Samarco, it didn't work out due to a competitive aspects, because the Court of Justice of Minas Gerais required a competitive process. And I also want to mention a case from Cuiabá, the FG, led by Dr. Nizey, who participated in the previous panel, where a dip was authorized based on the guarantees of the current assets. So these situations really lead to legal questions for us who have to interpret what the legislator says. I also believe, and now I'm almost done, that certain advantages of the dip are very interesting, but I don't know to what extent they'll really happen in practice. The aspect of immutability of a dip as a first level decision. What I see in practice is that lenders, lenders all still require a condition that precedes the disbursement, which will lead to a court decision not suspending the first level decision. If there's somebody appealing against the concession of the dip in the first level, the judge cannot suspend it to suspend the first decision, which in practical terms, the lenders, they are afraid that once the first level decision is made null, what they're going to do with that, the legal uncertainty remains. The second thing I see, I think, is about the subordinate guarantee, and I see it with a good pair of eyes. This allows negotiators to have a very important margin of negotiation, and I see some players using the possibility of having subordinate guarantee. And I think that there are aspects as well that lead us to certain questions, but still, which are very interesting. For instance, there is a provision saying that a dip will be automatically eliminated, but a super priority remains regarding the amounts that have been delivered and the guarantee as well. Okay, the effectively delivered amounts, but let's think about one thing. The remuneration of dip financing is a big incentive for funds to invest money in reorganization funds. Otherwise, these funds will start operating as banks. If they're coming to insolvent companies, it's because there's a new market, the market where they have a space that banks have difficulties penetrating due to regulations in this case. So in this case, what should be done? The amount, will it be simply connected to the amount that was delivered? And what about the compensation? It seems to me that the solution that should be found here, and I think that there's room in the law, in the terms of the law, if we systematically interpret the terms of the law, there's room for us to understand that the guarantee remains in case of a decision without full disbursement. The guarantee remains in terms of what has been disbursed, maintaining the percentage of coverage of the guarantee, because the guarantee does not need to correspond to 100% of the amount that was given as a loan. Usually banks or funders require a higher coverage of 120 or 150%. And I think that this ratio must remain. And there's no legal opposition to that. The second aspect relates to the order of priorities, because what would the compensation of these investors look like? Would they be protected as the second order of preference of payment in case of bankruptcy or not? I believe we do have room, according to the wording of the law, to say that yes, it would remain as second in the order of priorities. If it's not the case, it will go down a few steps and become the fifth to be paid in order of priority. So I think that there's that, and these aspects still have to be solved in practical terms. I think that in general, the law made good progress. We will see several dips. I think that the fact that a dip, the super dip, according to Article 69, is guaranteed by assets of the non-current assets, that's hindrance. So I do have restrictions against the decisions that are proliferating, granting a dip without this guarantee. And I think that this criterion chosen by the legislator is rational. And in the dip financing of the United States that inspires the law, it has a series of modalities and requirements with distinct priorities for dip financing. So nothing prevents different types of funding to exist and coexist. And our legislator so said. So it's very hard for us to interpret the law so openly. But that's something that is still to be seen in the future. So now I'm available for discussions. Thank you. Thank you, Fabi. I just want to highlight that you're so competent and you speak about this subject with such a confidence that you almost convinced me. We have to assume that everything is valid till proven the contrary. And picking up on what you said, the inspiration of the US that was applied with that, I'd like to invite Meng from China, which is a country that's been implementing for some time the DIP system. And they have several extremely important experiences about this subject, and she'll share with us. Thank you, Meng. You have the floor.
Okay, thanks, Biz. Yeah, and thanks everyone. And I'm Ming, and I'm the co-chair of IWIRC China. And I hope I can speak Chinese, and I will talk more. But unfortunately, I will talk in English. And my topic is DIP financing in mainland China. So first, the slide 2. So someone will to share the PPT. Yeah, the slide 2. And I will introduction the PRC DIP system. And here in China, the DIP system actually introduced in the PRC enterprise bankruptcy law in 2007. And also in this law, there is the DIP financing system. And but unfortunately, in the PRC bankruptcy law in 2007, there is no DIP financiers priority protect system. So only in 2018, in the third judicial interpretation of the PRC enterprise bankruptcy law by the PRC Supreme Court, and there is a rule in the for the DIP financiers priority. So after that, I mean after 2018, there are more DIP finance cases, which is popularly used in China. This slide 3, so I will introduction them. There are like two business operation ways under the PRC bankruptcy law. The first is the administrator takeover way, and the other is the DIP. It doesn't like in US. The DIP is the automatically applied in the US bankruptcy code. This slide slide 4, yeah. Yes, thank you. Unlike the US bankruptcy law, the DIP will be automatically applied. But here in China, the administrator takeover mode is automatically adopted unless the court approves the debtor's application for adopting the DIP. It means so here in PRC China, the administrator takeover mode is applied in most of the cases. So for some of the cases, if it's not much, the debtor applied to the competent court, they want to use the DIP after the court approves the application, and then the DIP can be applied. But here I want to make everyone know that no matter it's the administrator takeover way or the DIP way, the DIP financing can be applied. It means that under the administrator's takeover way, and also we can use DIP to finance the debtor during the restructuring procedures. Yeah. And also under the DIP mode, the debtor is allowed to manage its assets and business under the administrator's supervision. Slide 5. Yeah, that's the role of the administrator in PRC China. And in China, if once the bankrupt application has been accepted by the court will, generally speaking, the court will simultaneously appoint an administrator. And the administrator here in China plays a very important role in the DIP system. And even the debtor adopting the DIP mode, but is still under the administrator's supervision. So, although there is no specific rule to regulate what extent will the debtor be supervised in DIP mode, and in practice, major decisions like DIP financing will be subject to the administrator's as it may affect the creditor's interest. Slide 6. Thanks. So here in PRC China, there are a couple of methods to do the financing. The first is equity financing, the second is debt financing, and the third hybrid financing. And the most popular way here is the debt financing, and the second is the equity financing. And the hybrid finance actually does not apply much here in PRC China. And so we will talk one by one. And also for the debt financing here, like the borrowing money from the different, DIP financiers. And here in China, we will most cases will use the collective dates investment. So later I will talk it. For the equity finance, the slide 7. Thanks. For the equity financing, in this mode, share transfer includes the assignment of shares. Next page, thanks. Yeah, assignment of shares by the shareholders and the conversion of capital reserves to shares in the listed companies. So for the unlisted companies, they may use the shares. The shares can be transferred to the new investors, and for the listed companies, they will, generally speaking, it will capitalize the common reserves to the investors, which is like a very common equity finance method in Chinese judicial practice for the listed companies. And in one of our cases, and the investors they want to borrow money to the listed company, and they say they want to the shares of the listed company, and then at that time, so the debtor don't have to repay the money back. Slide 8, page 8. Yeah, thanks. So for the data financing, as it did here in PRC China, it's very difficult for the debtor in reorganization to raise funds by issuing the corporate bonds. So the borrowing money mainly exists in judicial practice, and per my knowledge, actually there is no, I didn't see any precedent for the debtor in reorganization to raise funds by issuing corporate bonds. And for the known providers, there's no entities, qualification, like limitations, like include, we can have like new borrowers, and also can have the original creditors, especially like the financial institution creditors, like the banks, etc. And also include the government funds and other relevant organizations. Also includes the individuals, and individual can also like lend the money to the debtor. And I mentioned the collective debt investment is one of the most popular debt finance method here in China. Especially in real estate, we see a lot of cases. Slide 9. So for the collective debts investment, loans are provided to debtors for the purpose of continuing business operation, and this is one kind of collective debts according to the PRC third judicial interpretation of the bankruptcy law. At current stage, no AMC, like the asset management companies, license is required for investing in collective debts, as I mentioned before. Thanks. And also, according to PRC bankruptcy law, the collective debts can be settled at any time. So it gave the senior priority over the unsecured creditors. Pursuant to the PRC third judicial interpretation of the bankruptcy law, although the collective debts investor is allowed to claim the priority over the general unsecured claims, however, the court will not support its claim for the priority over the claims previously secured against the specific property of the debtor. So in concluding, the collective debts investor stands at front line, but not the top. Yeah, this is their priority. Regarding the interest of the collective debt investment or the DIP finance here in China, the market is quite flexible. In one of our cases, the major shareholder lent money to the debtor, and the interest is 5% per year, actually, which is lower than the market price. And in the other restructuring cases, the interest will range from 8% to 20% per year. And in one of our real estate restructuring cases, the interest is 12% per year. Yeah, it depends how the bankruptcy administrator and the debtor, negotiate with them, with the DIP financer. So for the DIP finance procedures, it could be public and also it could be non-public. It depends the cases. And the second that it will negotiate with the bankruptcy administrator or the debtor. It depends which methods it takes. The bankruptcy administrator take over way or the DIP way. But anyway, for most of the cases, the bankruptcy administrator will make the final decision. Also, according to the PRC bankruptcy law, the loan plan will also be voted by the creditors' meetings. If there is before the first creditor meeting, the plan will be approved by the court. For the hybrid financing, it's not, as I mentioned, it's not used often here. It's combines the nature of the equity financing and the data financing. Here we use this way in the restructuring plan to compensate the creditors. Yeah, but not much in the DIP finance. Yeah, that's all from my side, and this is my email. Yeah, if you want to discuss further, you can drop me an email. Okay, thanks.
Ming, muito obrigada pela sua colaboração.
Thank you so much for your collaboration. Your lecture was extremely enriching for us to know how you've been implementing this system in China. So thank you for your time. I know it's late in the evening for you, but I'd really like to thank you for your participation and collaboration. And I'd like to take the opportunity that we've had this international collaboration, and I have the privilege of inviting Rosa Maria Vertis, who is an expert in insolvency. She is a lawyer from Mexico who is here to bring us the perspective of Mexico, which also applies DIP broadly. So you have the floor, Rosa.
Thank you very much, Bea. I want to thank IWIRC Brazil for the invitation to participate in this extraordinary Congress. I'm really happy to have joined this panel with so many talented professionals. So I really appreciate the opportunity. I want to thank Liv Machado and Bea for the invitation. Well, I will start first by speaking a little bit briefly about our Mexican system in order that you can understand better how the financing works. The next slide, please. Okay. In Mexico, we have only one formal proceeding. Okay, this proceeding is made of, we could call a pre-stage and then two stages. Why we need the pre-stage? Because according to our law, the judge can only open the proceeding if the debtor meets certain financial test. So the judge will ask, we have an institute that its main role is to register, to record insolvency professionals that will be registered there and will participate in formal proceedings. This entity appoints the insolvency professionals randomly. So upon the filing by the debtor, the judge will ask this institute for the appointment of what we call a visitador, which is usually an accountant that will review the financial statements of the debtor to make sure the debtor meets this test. If the debtor meets the test, well, then the proceeding will open and we will start with the first stage, which is the reorganization stage. This stage has a deadline in our system. It's a deadline of 185 days. So it's a short deadline, which can be extended twice for 90 days each, but it can never really go over 365 days. If the parties do not reach an agreement within this deadline, then the judge has to order the liquidation of the company. So many negotiations, take place before this filing. Now, please, the following slide. What does our law provide in connection with a debtor in possession financing? Since the debtor makes a filing, our law says that the debtor could request the financing. However, this doesn't really happen, in our cases because, at the filing, as I said, we have this pre-stage where the judge doesn't even know if it will open the proceeding because he needs this opinion, from the expert, providing if the company meets or not the financial test. So the law says it could happen, but even though, if the debtor does ask for the financing in the filing, this hasn't happened. Now, if this requested at the beginning of the proceeding, it would be the judge, the court, who would authorize the financing. Now, what happens if the proceeding is open, the first stage is open, the rule changes. According to law, it can be the conciliator, which is the insolvency professional that participates in this stage of the proceeding, the one that could authorize this financing. So this is quite good and flexible because it doesn't have to be the judge. It can be the conciliator, the one that approves and sets forth the terms of the financing with the creditor and the debtor. And obviously, the judge would have to be informed. This has happened, and I will speak of a case where this proved to be very successful. Now, we have certain problems with our debt financing. The financing was really introduced in 2014 in our law. However, under Mexican law, labor claims are always first priority, no matter what. So even if you have a debt financing, this debt financing would go after labor claims. So if you really want to have debt financing in a case, you must not have labor claims. I mean, that's like the first recommendation, because if you do, well, no lender will really be interested, in granting this loan, especially because labor claims, workers, employees do not even need to participate in the proceeding. If they have labor claims, they could go to labor courts, and they could get these courts to size assets of the company, even if they're secured. So it would be really very complicated, for the case. So the first recommendation for a debt financing is no labor claims. Now, our law also provides that when the proceeding is open and the judge, issues this judgment, open the proceeding and ordering a stay and many other issues, it can also expressly provide for these financings to continue, to be paid. So this also applies for executory contracts. Executory contracts that are not terminated by the conciliator because they're good, for the state. Well, this judgment can expressly provide, for the receipt of all these new monies, and the repayment, during the proceeding. I mean, this is very important because we want the liquidity. The company, in an insolvency proceeding, needs the liquidity, it needs the funding. And so all these, this financing, if approved and granted, could continue operating regularly. Next slide, please. Now, what are the issues that have to be considered in Mexico if you really want to have a debt financing? As I said, well, no labor claims, that's the first rule. Also, it would be recommended not to have tax claims. Tax claims, they're not above secured creditors, they're below secured creditors, but there are certain rules, certain restrictions, for haircuts. and in tax claims. Currently, our law says that if the tax claims are 60% or lower of the total debt, there could be a haircut, but this haircut would have to be at least, the least accepted by 50% of the creditors. So that has happened and has worked. But we have a not very good news. Last week, our government is proposing a reform, for in the budget for next year, and the government wants to delete, this article, so to forbidden any haircuts on tax claims. So if this happens, well, this would definitely make much more difficult restructurings, in organizations, but because there would be no discharge and no haircuts at all, in tax claims. So this makes this makes negotiations much harder. Now, what's another issue that must be considered if you want to use debt financing in Mexico? Our market is loans are mostly provided by banks. We have a small stock market, so banks are the main credit providers. However, they have many restrictions, in granting credit. On one hand, there's the Basel regulatory framework. If they're going to grant loans to an insolvent company, well, they would need 100% reserves, which makes, loans much more expensive. So usually they would not be interested. But above that, there's a provision in our credit institutions law that says that there's a potential criminal liability, for officers of financial entities or banks that grant loans to a debtor that foreseeably may not pay the loan. So this obviously is a big restriction also. So another issue is, well, we need to find another lenders because banks will probably not be willing, to grant the financing. So definitely find other lenders, private funds, wherever, abroad or in Mexico. Finally, the other issue that's very important and is to be considered is our courts. We do not have specialized courts in Mexico, not in insolvency and not even like in business matters. Are the judges that deal with these insolvency matters, they're really constitutional judges. So they don't like insolvency proceedings, and we've had really a hard time trying to convince authorities of the necessity of having specialized courts. This will cause us many problems. One of them is that we have very few cases because judges usually, repeal the matters. They don't like to admit them. And on the other hand, it causes a lot of delays because, they're not trained really in insolvency matters. So this causes cases to be lengthier and more costly. And this is not good for the financing. If the company needs the financing, it needs the financing quick because it needs the liquidity in order to continue operating. So that's why, next slide, please. Our successful, one case that's been successful, and I can talk about, was able to deal, with all these issues I just explained, was able to overcome this, which is like the recipe, for a successful debt financing in Mexico. Now, what is this? Well, first, this proceeding was terminated in 5 months, which is really a super, short term, for Mexican purposes. But the reason this happened was because it was a pre-PAC proceeding. Pre-PACs were introduced in Mexico in 2007. And there were some reforms in 2014. And these pre-PACs, they have proved to be like the best way to do a reorganization because you avoid part of this lengthy proceeding, when you follow the formal ordinary proceeding. How do these pre-PACs work? Well, all the negotiations among the parties are extrajudicial. This is similar to the London approach, that the negotiations are among the debtor and the main creditors. You need for a pre-PAC to be filed the approval of over creditors representing more than 50% of the total debt. So you would need to negotiate with these main creditors. You can choose, the parties can choose the conciliator, the insolvency professional that will lead this proceeding. In this case, it doesn't have to be appointed, by this entity I talked about at the beginning. As I said, the filing requires that the plan is approved by the debtor, and these creditors representing more than 50% of the debt. It is very interesting that in this case also the financial test does not apply. Remember I said at the beginning that the proceeding to be open, you need this pre-stage where this accountant is appointed to check if the company or the debtor meets the financial test. Well, we don't need this here. I mean, in this case, the debtor will under affidavit say, yes, I meet the requirement. This is my plan. I have the percentage required and I want to start my proceeding. So if the debtor complies with these requirements, the judge should admit the case. Next slide, please. What else happened? Well, I mean, once the judge admits the case, he would have to notify, all creditors. There's a short creditors' claims verification proceeding, and there's a term for objections. The judge submits the plan for approval of all creditors, and the case, if the plan is approved, the case is terminated. So it can be very efficient. What happened in this case? Well, as I said, no labor claims, no tax claims. It was very important. The company, had been continuously paying all these debts, all these obligations. So in order that this would not be a problem, for the restructuring. Also, the lender was not a bank, it was a private fund. And the negotiations, took place, they started about a year, before the filing, because it was, I don't know, about around $400 million debt. So there were many creditors, there was a lot of negotiations. And during this term before the filing, that this lender agreed, just to do this funding. So started doing the funding. Obviously, at that point, there was a credit agreement, some security interest, there was a pledge in shares. And upon the filing, there was another portion, of this loan that was granted, and it was approved, as I said, by the conciliator, just informed to the judge. And this loan will have first priority in the proceeding. The plan was approved by approximately 57%, of creditors total debt. And well, the agreement, contained provisions recognizing, this loan is first priority, and repayment in cash, and also there was capitalization, of many of the debts of the creditors, during the proceeding. Next slide. Due to all these circumstances I've been talking about, what has happened in Mexico is there's a tendency, as long as we do not have this specialized courts, there's a tendency to try to improve very much the out-of-court negotiations. So the Association of Banks in Mexico has been working on a protocol, to like some guidelines to try to do these negotiations more efficient, and there are many rules, but I just comment 2 or 3 that are relevant to our topic. Well, one of them, the most important one, is all parties have to collaborate. The debtor has to collaborate, provide all information that's required. And this is very important because as this is out of court and there's no order, by the judge, lenders are free to enforce their security interest or to start legal actions or whatever. So the debtor has to, very formally comply with these requirements in order to, if it really wants, to have this agreement. Now, this rule is also applicable to lenders, because there should be no shadow negotiations. Lenders should be treated equally, and they should say since the beginning, if there are certain agreements they would not accept, because we don't want to waste time, during the negotiations. We want to know what is a real, a suitable agreement that would be feasible and that would be satisfactory for everyone, since the beginning. Obviously, no preferences among creditors. And as you know, well, existing lenders don't like other lenders to have this super priority, before them. So there's the intention here is that all participating creditors in these negotiations participate in this debt financing. So the idea is if we all participate, this debt financing will have the super priority, but that's why we need everyone here to get involved, to make the commitment in order to all of us, be happy with the super priority because it will include all of us. So those are some of the rules that have been discussed and negotiated, and will hopefully, we'll have this guideline soon. And well, that's really, I think the most important things, I can say. I'm happy to answer any questions or comments from the audience.
Rosa, muito obrigada pela sua colaboração, interessantíssima.
Thank you very much for your very interesting collaboration and your perspective. And it's very interesting for us to look at the different realities in China and Mexico, where we already see that there's a doubt between potential frauds. So it is something which is very interesting for us to see the perspective of both sides on how this is being presented. So thank you very much, everyone, for your participation. Due to the time, we will not have time for Q&A, but we will all be available to answer the audience. If you have any interest, just contact our email in IWIRC Brazil, and we will send the questions. And I would like to call Diana for the wrap up. Once again, thanking you for the opportunity and for the invite to participate here. Thank you very much, and I wish you all a great day. Thank you, Bia. Thank you, all panelists. It was truly a very fruitful morning. I hope you've all enjoyed it as much as I have. And I'd like to invite you before we close for the next day of the event, which will be on the 16th on Friday. And the panels presented will be the sales of assets and insolvency starting at 9. And to wrap up, we will have the draw of the kit, the personalized gin and tonic glass, and the CMR book. I think Grazi will share the screen with us for us to be able to do that with everyone who has enrolled. Okay, so let's first do the kit, please. So Milena Damolin, congratulations. You're going to get our kit with the glass and the gin. And now the book that CMR gave us. Beatriz Lima da Silva, congratulations. I'm sure you're going to love the gifts that you're going to get, and I hope to see you all again on the 16th. Thank you very much. Bye-bye to everyone, to the speakers, to the moderators, and to all the event organizers. Thank you very much. Bye-bye.
Thank you.
Be inspired. onde tudo começou. O IWIRC foi fundado em dezembro de 1993 por Celina Melnick, uma advogada, Lauren Ryan, uma analista financeira, e Marta Fettner, uma banqueira de investimento, para capacitar e encorajar as mulheres no campo da insolvência. Os primeiros membros aderiram em 1994. Em 1995, já contávamos com as 3 primeiras redes estabelecidas e, desde então, assim como formiguinhas incansáveis, formamos